All rise. The Honorables, the presiding judge, and the judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to the North Carolina Court of Appeals. I'm Judge Allegra Collins. To my right is Judge Jeff Carpenter. To my left is Judge Julie Flood. Our clerk today is Dee McGessie. Our marshal today is Officer Tom Salou. Thank you for being here. We have one case on the calendar today. It is 25-130 Randolph County Board of Education versus Stein. Counsel, are you ready? You may proceed.
May it please the court. My name is Jim Doggett, and I represent the defendants in this appeal. I'd like to reserve 5 minutes of my time for rebuttal.
Yep.
Your Honors, this case calls on this court to consider the validity of a long-standing environmental grant program that has greatly benefited our state for more than 2 decades. Despite those benefits, this case also unfortunately marks the latest in a series of legally meritless attempts to redirect the funding for the grant program away from its intended source. To try to show that redirecting the funds is needed here, the plaintiff in this case, Mr. Burris, makes a series of strained arguments that, if accepted, would profoundly disrupt both appropriations enacted by our General Assembly and also charitable giving to the state. Fortunately, the disruption that Mr. Burris asked for is unnecessary because the law is decidedly against him. He lacks standing to assert the claims that he makes today. And also his claims fail in the merits, both with respect to the funding from 2021 to 2025 for the grant program and also for the funding for 2019 through 2021. If I can, I'd like to start with standing. First, Mr. Burris lacks standing to assert all of his claims as a taxpayer on behalf of the Randolph County Board of Education. He lacks that standing because he can't show any sort of direct injury that he suffered as a result of the operation of the program.
Doesn't he have relator status in this matter?
I'm sorry?
Doesn't he have relator status in this matter?
That's correct. That's correct. He does. But
Does he need standing on his own if he's a relator for the Board of Education?
yes, he does, because that's what our Supreme Court unanimously held in Farrington last year. In a unanimous decision, the court held that a relator such as Mr. Burris must show a direct injury to just have taxpayer standing, both for challenging legislative or executive acts. So I don't think there's really possibly any real dispute after that unanimous decision that he must show a direct injury here today.
Can you tell me what a direct injury would look like if it isn't that the schools don't have the funds that they were supposed to, and thus his essentially taxes are diluted?
Well, I read his brief very closely, and I don't really see him to say that he has any direct injury in this case other than simply saying that this case is akin to the Farrington case. But in the Farrington case, you had someone who had to pay a parking ticket, or I'm sorry, not a parking ticket, a red light ticket, and so his funds have been extracted. But there isn't anything like that here today. These funds were a gift from Smithfield. And this is not only, I mean, we don't even have to think about this from the standpoint of first principles.
The gift from Stanfield, that's a conclusion that I picked up in your briefing. How is that, in your mind, how is that established that it's a gift?
I don't think
the Supreme Court says it's not a penalty in New Hanover 1, so I'll give you that. How do we get to a gift?
That's an issue that's not been disputed in the course of this litigation. I think, you know, the fundamental basis of their claim is that these funds are gifts that had to be deposited in the state treasury, so that underlies the nature of everything they're claiming today. And that's they allege in their complaint, I believe as well too, that's a gift. So it's just
if it's a gift, does that mean that Smithfield can just stop paying?
No, Smithfield has an obligation to continue to pay, but
an obligation to give a gift.
Right. Yeah. I mean, I think it's a charitable pledge. That's how gifts work. That you can say, I'm going to make a gift to the state or someone else, and in exchange, the state agrees to spend that money for a specific purpose. And it's typically called a charitable pledge. I don't think it's that common. I think it's that uncommon. But again, I'd like to stress again, this is not an issue that's been disputed. I think everyone agrees here this is a gift. And you can ask my colleagues here and my friends here, and I think they would agree with you this is a gift because this underlies the nature of their claims, because we wouldn't be here otherwise. But again, we don't need to think about standing from first principles, because in the DeLuca case 7 years ago, this court addressed this very issue, and it held that a taxpayer who was similarly situated to Mr. Burris lacked standing to assert claims because he couldn't demonstrate any direct injury from the operation of the grant program. And that's something that in their, we pointed this out in our opening brief. In their response brief, they entirely ignore it.
If the argument is that there are less funds in the public school system than there would be if this money were properly put in there, correct? That's the argument. This money should be in the school system, and now there is less money because this $2 million per year isn't put in there, correct?
Well, I don't know that. I mean, they've not made that argument.
Okay.
That's not Farrington, and they basically say we've suffered a direct injury because Farrington is just like this case, and that's not what this case is. And I think if you think about it, if that were a theory of taxpayer standing that were acceptable, that would allow essentially anyone to sue. Everyone in this courtroom, because we pay taxes to the state, would be able to sue in this circumstance. And even somewhat, you can think of even more attenuated examples, like tax. Sometimes people from outside North Carolina pay North Carolina tax. Imagine someone who's driving from New York to Florida and stops to buy a Diet Coke in a convenience store, and they pay sales tax. That person could conceivably have standing as well, too. So I think what they're advancing here is really an unbounded theory of taxpayer standing. And again, I don't think this court needs to even address these issues. This issue is a matter of first principles, because the DeLuca case already covers this. And my colleagues here simply ignore it because they have no answer for it. It's rare that we have a case where precedent so clearly controls an issue as this one, where we have a plaintiff who's similarly situated, who's making a claim of taxpayer standing. We have exactly the same program, the Smithfield Environmental Enhancement Grant Program. It's exactly the same, and they have no answer for it. And I'd also like to point out that they also lack standing separately for another reason, to advance another one of their arguments in their brief. So several times in their brief, they make a suggestion that the funding for the grant program was not properly appropriated within the meaning of the appropriations clause under the 2019 statute that required gifts to the state to be deposited in the Treasury, and also recognize the terms of those gifts as binding. In Stein 1, our Supreme Court held that school boards, and they stand in the shoes of the school board here, lack standing if they can't show that a claim would provide any recovery for the school board. And that's the case for this claim here. They haven't made any showing that there would be a recovery for the school board if they were successful in that claim. And that's different from their other claims. Their claims under the civil penalty clause, under the gift clause, those claims clearly relate back to school. So if they have taxpayer standing, they can advance those claims. But as to that specific appropriations argument they make with respect to the appropriations clause, they lack standing there. If I can, I'd like to move on to the merits. So first, with respect to the funding for 2021 through 2025, they argue that the appropriations clause and the civil penalty clause of the state constitution require that funding to go to schools. And if I can, I'll briefly try to recapitulate their argument so I can respond to it more easily. Now, they can correct me if I'm wrong, but as I understand their argument, they believe that the 2021 and 2023 budgets that were enacted by our General Assembly created a new civil penalty fund. So we already have a statutorily created civil penalty fund under Chapter 115C that already exists. Their position is that those budgets created a new civil penalty fund and appropriated the Smithfield funds into that fund, and as a result, that shows that the funds have to be spent on schools. And that argument fails for a number of reasons, but most principally it fails because those budgets can in no way possibly be construed to create a second civil penalty fund. And let me explain why. There are a couple reasons for this. So first, if the General Assembly were going to create a new civil penalty fund, which would be kind of an extraordinary thing, you would think they would at least enact a statute that's similar to the statutes in Chapter 115C, or at least amend those statutes. And many of them would necessarily be a necessary predicate to create a second civil penalty fund. because those statutes expressly say that all civil penalties have to be paid over into the real civil penalty fund that has existed in our statutes for decades. That's what they say. But the General Assembly didn't amend that. Instead, what the General Assembly did is they have made appropriations to the Department of Justice. And you can see this on pages 183 and 185 of the record, which is the proposed budgets that were proposed by the governor that the General Assembly enacted without change. And they clearly show that what the General Assembly did is they appropriated funds to the Department of Justice. And they just didn't do that. They also appropriated them using a fund code that showed that the funds were meant to be spent on Smithfield environmental enhancement grants. And that's controlling here. And we know that's controlling because that's what the State Budget Act says. The State Budget Act says that appropriations relate to the programs or purposes that are laid out in the 9-digit fund code that's laid out in the governor's recommended budget that the General Assembly doesn't change. So we have an appropriation here to the Department of Justice to support Smithfield environmental enhancement grants. That is not, in no way can that enactment possibly be construed as creating a second civil penalty fund, which would be an extraordinary thing for the General Assembly to do.
So when I read these funds, they are for civil penalties, forfeitures, and fines, correct? These
No.
funds are directed. No.
No. I think what you may be referring to is the General Assembly, when they, first of all, these are not civil penalties, these are gifts.
Correct,
That's agreed.
but I'm asking what the verbiage is when we're looking at the Constitution, and the Constitution directs a fund to hold these monies for the public schools, correct?
Correct.
Okay. Those funds are for civil penalties, forfeitures, and fines, am I correct or no?
Correct.
Okay. All right, so we're on the same page there. We have a gift over here, and we have a fund that's supposed to hold civil penalties, forfeitures, and fines, correct?
Correct.
If a fund is a gift,
Right.
gets deposited into the actual civil penalties, forfeitures, and fines fund that's supposed to go to the public schools, does it convert what this gift was as soon as it touches the bank account?
I don't think this, I don't think it does, but this court doesn't need to reach that issue because everyone agrees, and I think this is correct, everyone agrees that the funds issued here were not deposited into the real civil
I know,
penalty fund.
but I want to reach this issue. So if we did actually put it into that specific fund, let's just say it's by mistake,
Right.
does it convert those funds?
No, I don't think so. I mean, I think what the civil penalty fund was created to do was to allow the state to create a statewide fund and to take out a way that it could do that.
Okay.
And it also contemplated everything put in that would be a civil penalty, and the consequences of a contrary rule that would allow this transformation to take place, I think are kind of crazy. I mean, imagine if like a budgeting error at OSBM, someone pressed the wrong button someday, and the entire state budget were placed into the real civil
That's my
penalty.
question. As soon as it hits that account, all of a sudden, does it go to the public schools?
Well, that would be, no, I don't think so. And that would lead to, the potential for small mistakes, which this case doesn't involve, to lead to.
And I understand that you're not saying it is that specific fund, but that's what I'm asking. It doesn't, if it were there for a mistake or just because it goes into a fund for civil penalties doesn't mean it actually is a civil penalty, correct?
And everyone agrees about that, and that's what the Superior Court held as well in its decision below, that the nature of these funds were not transformed by the fact that they went into this second civil penalty fund, which is different from the one that's actually constitutionally authorized. But just, again, I think that would be really crazy if that were the result, right? I mean, if a mistake at OSBM or the controller's office were made and the entire state budget were jumped into the civil penalty fund, all of a sudden the entire state budget has to be spent on schools. And I think that result is so crazy that it kind of disproves the argument. But I would like to, but I would like to explain what did happen here, and what is the basis of their argument, I think. And that's that when these funds were appropriated, they were appropriated using a budget code, and that's different from a fund code, that was labeled seized and forfeited assets. But the effect of that, basically the only thing the fund code serves to do is to designate the sort of the fund type of the funds at issue. And we can see that in the state budget manual when it says budget, it actually defines, it says fund type equals budget code. That's what it says. And so in this case, what the budget code that was used here served to do was just to designate these funds as special revenue funds that were restricted and couldn't just be spent on anything, unlike, say, funds in the general fund. That's legally what it was meant to do. And again, so we shouldn't, in determining what these funds were appropriated for, the budget code is sort of a nullity. It just doesn't doesn't enter into the equation. Instead, we need to be looking at the 9-digit fund code. And the specific statutes to look to that are 143C 6.1, which defines sort of what an appropriation is. In this or defines what is appropriated when the General Assembly doesn't make a change to the governor's budget, and then looked at 143C11D23, which specifically defines program or purpose and says that what's controlling is the 9-digit fund code. And again, if you look at pages 183 and 185 of the record, there really can't be any dispute. The fund code here relates to Smithfield Environmental Enhancement Grants. So really, it's not even a particularly close question. These funds were appropriated to DOJ to support the Smithfield EEG program. And also, there's another way we know that too. Before this budget code was used for the Smithfield funds, it had previously been used to appropriate funding certain federal funds to certain agencies, including the Department of Justice. And in the Memorandum of Additional Authority that we filed at the end of the week last week, there we see the General Assembly expressly recognizing that this fund code would not have the effect of creating a new civil penalty clause. Instead, recognize that funds that fall under it would be credited to the budget of the Department of Justice. So we already know, just based on the background rules that govern budgeting, that the fund code controls here. But we also note that these additional appropriations the General Assembly made, that specifically here, this budget code could not have possibly been understood to take the extraordinary step of creating a new civil penalty fund. And I'd also like just to pause briefly and note how destabilizing for the appropriations process, for past appropriations that have been enacted and possibly future appropriations, accepting Mr. Burris's arguments would be. On page 14 of our brief, we cite in the footnote on that page a spreadsheet that lists other budget codes that existed under the state's prior accounting system that was in effect for the relevant dates of this case. And if you look at those budget codes, what you'll see is a lot of them refer to the general fund. So one of them, for example, is insurance general fund. Another one is DPS general fund. And as I understand my friend's arguments here, their position is basically the budget code should be read as controlling what things are appropriated to. But if that were true, that would possibly, it's unclear exactly what their arguments mean, but that could possibly mean that that those appropriations to DPS, to the Department of Public Safety, to the Department of Insurance, and lots of other agencies could end up being rerouted back to the general fund. So their arguments could have the possibility, and it's hard to say exactly how severe these possibilities are, but of possibly destabilizing the meaning of billions of dollars of appropriations. Billions of dollars. And so I just ask this court to keep that in mind, that as it decides this case, no matter what this court thinks about the Smithfield Environmental Enhancement Grants Program, keep in mind the broader consequences of what's going on here. And I'd also like to, if I can, now turn to the funding that is at issue for 2019 and 2021. And so there, my friends make a different argument under a different clause of the state constitution. They take the position that those funds have to go to schools under the gift clause of the state constitution. And the gift clause, I won't read it to the court directly because it's kind of a mouthful. But in essence, it says that funds that are gifted to the state have to go to schools if two conditions are met. First, the state hasn't appropriated those gifts for another purpose. And second, the terms of the gift don't appropriate the funds. So, and as our Supreme Court said in the Cooper v. Berger case, effectively what this means is that general gifts to the state have to go to schools. So if someone gives a gift to the state for an unspecified purpose, or a bequest or something like that, and they say, I just want to give to the state of North Carolina, and the General Assembly doesn't appropriate for another purpose, then it has to go to schools. But here, this clause doesn't even come into play, because if you read the Smithfield Agreement, which sets forth the terms of the gift that Smithfield made, and specifically if you look at page 166 of the record, which blends over into 167 a little bit, these funds were unmistakably given to support a grant program for environmental purposes administered by the Attorney General.
So if you have something that is specifically designated for one purpose but appropriated for a different purpose, which controls, is this an or an and?
I think it's an or. It's an or. So basically, I don't think the state has unlimited authority to appropriate gifts, contrary to terms of gift. There are background principles of law, such as the Contracts Clause, that limit what the state can do in this area. But the gift clause doesn't really deal with that. It just basically says, I think what it says, if the state gets a general gift and the General Assembly appropriates it for another purpose, it doesn't have to go to schools. And it also says if the state gets a general gift that's not given for a specific purpose, then it has to go to schools. But here, the Smithfield gift was given for a specific purpose of supporting the Environmental Enhancement Grant Program. And so as a result, the clause just doesn't apply.
Is this agreement, is it a contract that we're talking about that designates what this gift is for? Is that a contract or?
Yes.
It is a contract.
It's a contract, that's right.
Yeah. Is there any, I can't think of the word right now, but if, for example, this gift does not go to an environmental fund, as the contract says, can they pull out of the contract without impunity? Has it been breached?
I mean, I think that would be I think that's possibly that might be a breach. If the state were to act in a way that was inconsistent with the Smithfield Agreement, that might be a breach that would justify Smithfield walking away. But as to the gift clause, really the whole issue is the question is whether or not the terms of the Smithfield Agreement specify a purpose for the grant funding other than schools, and the answer is it does. So the clause doesn't apply, and it's pretty simple. And so just to sum up, basically, with respect to the 21 through 25 funds, there we know that the funds would have to go to schools because they were appropriated under a fund code that showed they were appropriated to the Department of Justice to support the Smithfield Environmental Enhancement Grants. And with respect to the 19 through 21 funds, those funds don't have to go to schools because Smithfield's gift specified a specific purpose on which its funds were meant to be spent. And honoring those terms are part of the state's contractual commitments to Smithfield. And if there are no further questions, I would reserve the rest of my time.
Just one question. I'd like you to address the future funding.
Yes.
And how you feel that this order can't control future funding.
Right. Well, the Superior Court's decision held that the school funding had to go to schools based on specific things that had happened in the past. That it construed appropriations enacted by the General Assembly to believe that the funding had to go to schools. And it noted that in its belief, certain funding had not been appropriated by the General Assembly. But those are all things that are backward-looking. They aren't forward-looking. And so the decision below provides no basis for issuing any decision.
So things can change in the future, essentially. And
we don't know what's going to happen. But, we're waiting for a budget to be enacted. And I don't think they disagree with that point. I mean, I read the latter part of their appellee brief to essentially be, to say, yeah, defendants are correct about that. And so, I don't think that's really a disputed point.
thank you.
Thank you.
May it please the court. My name is Dan Gibson, and I represent plaintiff appellees in this case. There was a time in North Carolina when the Attorney General or other state officers could hold state funds in private bank accounts. That time was up until 2019. The record in this case shows that's what happened for the majority of the Smithfield Agreement. From 2000 to 2019, those funds were held in a private bank account controlled by the state Attorney General. That time ended when the General Assembly passed 147-76.1, requiring all funds belonging to the state of North Carolina to be placed into the state treasury. And that's what we alleged in our complaint. We didn't allege whether they were grants, gifts, devises. We said they're funds belonging to the state, and under the statute, all funds belonging to the state, regardless of how they're denominated, have to be deposited in the state treasury. And then once they're deposited in the state treasury, Article 5 controls. Article 5 says that no funds leave the state treasury but by an appropriation of law. And that is what the General Assembly intended when it passed this statute. It said, we're cutting off that loophole. There are no longer going to be state funds outside of the state treasury. All of the state funds go to the state treasury to be appropriated by the legislature. So the question in this case is what the legislative appropriation is. And the legislative appropriation is clear. The appropriation is to seized and forfeited assets. And to answer Your Honor's earlier question to my friend on the other side, we believe that the General Assembly's appropriation, if they say they're seized and forfeited assets, and the Constitution says the civil penalty fund is for fines, penalties, and forfeitures, that the appropriations language controls.
The
General-
Supreme Court says this is not a civil penalty.
That's correct. So I would say apart from the General Assembly's appropriation, these would not be subject to the civil penalty fund. But the General Assembly can take non-civil penalty funds and appropriate them and say, we are going to treat these as though they are fines, penalties, and forfeitures. And the reason why they can do that is because the Constitution is not a grant of authority to the General Assembly. It is a limitation on the General Assembly's authority. So unless the Constitution says, no, you can't do that, the General Assembly can do it. So when they pass a law that says it is to seized and forfeited assets, that appropriation controls. That's the General Assembly's decision. If you think it's a mistake, you can go to the General Assembly and say, we would like you to correct that mistake. But it's not for us, anyone at the Office of State Management or Budget, or any court to come and correct a supposed mistake in the General Assembly's appropriation. And I want to be clear that that's actually what is in the record in this case. They might not use the word mistake, but 3 of the affidavits from the Office of State Management and Budget specifically say that the fund code is incorrect and does not accurately reflect the current use of those funds. That's at record page 131, paragraph 10, record page 134, paragraph 7, record page 139, paragraph 6. We don't get to say that the laws passed by the General Assembly are incorrect. If the General Assembly made a mistake, it's on the people alleging that mistake to correct that mistake through law. It is for us to interpret what the General Assembly's laws mean. And when we're interpreting those laws, we look at all of the words in the statute. Yes?
So the budget says X. The Office of Budget Management says that's incorrect. Do we just go with Office of Budget Management and ignore the General Assembly?
No, that is absolutely not my position. But the position here is the way the budget process works is the governor prepares a recommended base budget. And that is at record pages. It's actually attached to the defendant's affidavits. It's Exhibit 5, which is record page 175. And if you look at record page 175, it has a budget code, 23606, seized and forfeited assets. And then below that budget code, it has a separate fund code for Smithfield Environmental Enhancement Grants. Now, the defendants elaborate on that fund code with documents produced by the Office of State Management and Budget explaining what that fund code is. The problem with that is those were not passed as part of the Appropriations Act. They were not made into law by the General Assembly. What was made into law by the General Assembly is at record page 175. They enacted the governor's recommended base budget. The budget bill the General Assembly passes generally sort of modifies the recommended base budget. They say we're going to move this line item over here, so on and so forth, but unless it's been specifically changed by us, it becomes law. In this case, there was no specific change to what you see at record page 175. So the court's task then is to say, how do we interpret seized and forfeited assets and environmental enhancement grants together?
Can you point me to record page 175, what you're talking about? I don't see it on either PDF 175 or the actual record 175. Am I looking in the wrong place?
I'm sorry, I'm citing the wrong record page to you. The pagination in front of me appears incorrect. I'm sorry. It's Exhibit 5 to the defendant's affidavits. I'm sorry. I'd be happy to file a supplemental document citing to that specific record page.
I'll find it. I just can't follow along with you as you're talking about it.
I could use the Elmo here.
We'll be all right. Just keep talking. I will know what to look for.
Opposing counsel helpfully has pointed me to record page 183. Thank you. I don't know how I printed a copy that didn't have the correct record pages on it. So it's the recommended base budget worksheet 1.
Got it.
And you'll see at the top underneath Department of Justice, it says Justice Seized and Forfeited Assets, and then there's a fund code below that for Smithfield Environmental Enhancement Grants. So the question is, how do we interpret all of that language together? Because this is part of the law, and when we interpret the law, we don't get to read words out of it. Opposing counsel suggested to you that the budget code is a nullity. That's not what we get to do. We have to look at the law, and we have to say, what does the law altogether mean? So seized and forfeited assets has to mean something. Our position is the clearest way to read seized and forfeited assets, we have a constitutional provision that says fines, penalties, and forfeitures go to the civil penalty fund. Forfeitures means just that.
How do we
It's a forfeiture.
reconcile that position with what the Supreme Court's already held as to this particular funding?
I think the way you reconcile that is the Supreme Court's decision controls unless the General Assembly makes another appropriation. So the Supreme Court says these are not just by virtue of them being given to the state of North Carolina civil penalties. But that doesn't prohibit the General Assembly in its legislative appropriation authority from saying we're going to appropriate them to that fund anyways. So the appropriation, as Judge Collins asked earlier, I think the appropriation to the civil penalty forfeiture fund makes them fines, penalties, or forfeitures. I'd also note that the Supreme Court's decision solely dealt with the civil penalty issue. It didn't address whether they were fines or forfeitures. So the General Assembly can come along and say, these are forfeitures. We are using our legislative authority to appropriate them there.
So an agreement between Smithfield and the state, once they pay those funds, the General Assembly can essentially change what the agreement is and classify them as a different type of fund? It can reclassify a gift into a fine even though the agreement says it's a gift?
So there's two ways. Well, the agreement, first of all, doesn't say it's a gift. It calls it an environmental enhancement grant.
Okay.
So there's two parts there. One is the funds become subject to legislative appropriation once they enter the state treasury. I think everyone agrees on that all funds that are in the state treasury are subject to legislative appropriation. The question then is, what is the limit of the General Assembly's appropriation authority? The Constitution doesn't provide one. If the Constitution doesn't provide one, it's black letter law in this state that the General Assembly has the authority to do whatever they want to. So the General Assembly can say, we are going to label these seized and forfeited assets. We're going to treat them as part of the civil penalty fund. And I'd point out that the trial court's order here is still preserving the underlying purpose of these funds. These are still being used for environmental enhancement. They're just being used for environmental enhancement at schools. That's how you interpret seized and forfeited assets and environmental enhancement grants together and consistent with one another, which is what the court has to do when it's interpreting statutes. We don't read words out of the statute. We try to harmonize the statute whenever possible. So yes, it's my position that the General Assembly has the authority to take whatever funds are in the state treasury and appropriate them wherever they would like. And in fact, Cooper versus Berger even suggests that. Cooper versus Berger dealt with the same civil penalty language that we're talking about here. The governor in that case argued that federal grant funds were otherwise appropriated by the federal government. So they were custodial funds that were not subject to legislative authority. The Supreme Court said no, all funds in the state treasury are subject to the General Assembly's exclusive authority. So these are not separate custodial funds. And Cooper versus Berger even suggested if the federal government believes that those grants are being improperly appropriated, the federal government can sue. I think arguably if Smithfield felt these grants are being improperly appropriated, that it could sue and say, we don't think that they're going to the purpose that we had in mind, which was environmental enhancement. But that goes to the point of why Smithfield is giving these funds. The point isn't the Attorney General picking the beneficiaries. The point is environmental enhancement being tied to Smithfield. Because the problem they were responding to is that the hog lagoons owned by Smithfield had caused environmental damage. And they wanted to be seen to be remediating that damage. So the use of funds here for environmental enhancement across the state of North Carolina can be seen as we are remediating, we're making good on the harms that we've made to the state's environment.
So if the Attorney General were to use these funds for various schools, for grants in various schools, would we be here?
I'm not sure that we would. I think the issue in that case would be that the appropriation for the civil penalty fund, the specific constitutional language says that it has to be appropriated. I think the General Assembly has passed a law saying it's average daily membership of public schools. It goes evenly to schools throughout the state of North Carolina.
Okay, so in that instance, the General Assembly wouldn't be saying that the schools got it. The Attorney General would be saying the schools got it and would be okay with that.
I think if the General Assembly was, or if the Attorney General was following the state constitutional mandate that this fund goes to the schools and it was being appropriated as required by the Constitution, sort of equally across the schools throughout the state, no, I don't think we would have a problem here. The issue is not that the Attorney General is dispersing these funds. The issue is that the Attorney General is dispersing these funds contrary to a legislative appropriation. And that gets to the direct injury question that we talked about with standing here, which is direct injury is when you're arguing, I would say, a law is unconstitutional. There's some dicta in Dan Forrest and Farrington suggesting that when you're arguing an executive act is unconstitutional, it also applies. But I don't think the court needs to reach that issue because at this point we're no longer arguing about whether or not the Attorney General is acting constitutionally. The argument is about what the legislative appropriation is and what the legislative appropriation means. That's no longer a constitutional argument. We're not arguing about Article 5. As I understand my friend on the other side, he's conceded that the General Assembly has authority to appropriate these funds. His argument is just the General Assembly hasn't appropriated the funds as we believe the General Assembly has appropriated them. But even independent of that, Farrington, and we made this point in our brief, Farrington holds that unlawful expenditures resulting in additional financial burden on a taxpayer give that taxpayer standing. So even if you need direct injury, Mr. Burris has direct injury as an individual taxpayer. He's alleged, I'm a taxpayer of Randolph County Board of Education, and because you're taking these funds from Randolph County, I'm going to have to pay more taxes. That's sufficient for taxpayer standing. But again, I don't think the
where is it that we can tell that he's going to have to pay more taxes?
we've alleged that in the complaint.
Yeah.
Um,
But is there any basis for that allegation? Wouldn't it just be that the schools had less money?
I think it is
happens
just that the
all the
schools have
time.
less money,
Yeah.
and it certainly does happen all the time. But I think the court doesn't necessarily have to reach the direct injury issue for two reasons. One, the constitutional argument that we just made. We're no longer arguing about the Constitution. But second, our courts have distinguished in Farrington and in DeLuca versus Stein between general taxpayer standing and relator taxpayer standing. So in DeLuca versus Stein, the court said a taxpayer may have had standing to bring taxpayer action not as an individual taxpayer, but on behalf of a public agency or political subdivision if the proper authority neglected or refused to act. Now that's the Court of Appeals opinion in that case because that's the one that directly addressed DeLuca's standing as an individual. By the time we got to the North Carolina Supreme Court, it was New Hanover County Board of Education versus Stein. There was no standing issue. DeLuca wasn't contesting the standing issue. So the Court of Appeals opinion most directly addresses that issue. It says no, Francis DeLuca does not have individual standing as a taxpayer under Goldston, but he might have had relator standing. The problem for DeLuca in that case was he didn't make any showing that he made a demand on the relevant Board of Education or that a demand on the relevant Board of Education would be futile. That is not the case here. Mr. Burris argues in his brief, yes, I made a demand. In fact, the demand letter and the board's response are included in the record. So he says, I would like you to file this suit, Randolph County Board of Education. The Randolph County Board of Education says, we commend you for your civic spirit, and we hope that you succeed in this lawsuit. That's sufficient under Trogdon, under Farrington, under DeLuca, under just about every case dealing with relator standing to give Jonathan Burris relator standing. And that's a distinct doctrine from Goldston. If the defendants were correct, Goldston would control in every single case. There would never be a separate category of relator taxpayer standing. So the standing argument there, I think, just really misses that there is a separate subcategory of standing for a taxpayer who sues on behalf of a Board of Education.
So there is no sort of intertwinement between where the funds might end up and if this actually ends up in the public schools funds, that affects standing whatsoever. This is a different argument.
Do you mean in terms of whether or not Jonathan Burris would have additional financial burden, or?
Yeah, I mean, I think I'm going back to just making sure that that I understand you correctly, it doesn't matter if the funds end up in the public school system or not, because or whether he has to pay or not. It's simply his demand on the school system to file suit, and they wouldn't, gives him standing.
It's that plus the funds allegedly belonging to Randolph County Board of Education.
Okay, so you gotta have both.
Yes.
Okay.
So it doesn't have to be a loss of funds from him. It has to be a loss from the Randolph County Board of Education. And Trogdon and Farrington both say that. Farrington says a taxpayer may sue on behalf of a public agency or political subdivision for the protection or recovery of the money or property of the agency or subdivision. And that's exactly what we're doing here. Our argument is these funds were appropriated to the civil penalty fund, and in the years that they weren't appropriated, the default provision governing grants, gifts, and devises to the state of North Carolina applies, so they go to the civil penalty forfeiture fund, and the Constitution says that the civil penalty forfeiture fund goes evenly to the school boards throughout the state of or the public schools throughout the state of North Carolina. So we are entitled to our share. And understanding, I would say if you sue and you say, you owe me $1, you have standing to sue and say, that's my $1. I'm going to go to court and vindicate my right.
And you might still lose, but you have standing to challenge.
Yes, you have standing to challenge it, but you may still lose. So I think the standing issue, and United Daughters of the Confederacy makes this clear, standing is sort of a prerequisite issue before you actually get to the merits. So when you're talking about standing, it's are you making a claim for these funds? And then we might ultimately hold that those funds don't actually belong to you, but the holding that the funds don't belong to you doesn't mean that you don't have standing. Otherwise, you'd never get cases where you hold that the funds don't actually belong to you. So that's why we have standing here, because it's separate relator standing. And so our argument on the appropriation issue is once the funds enter the General Assembly, enter the Treasury, they're subject to the General Assembly's control. So there's two cases here. One, which we've already discussed, where the General Assembly makes an appropriation, as they did here, to seized and forfeited assets. The question is what happens if there's no legislative appropriation and the state constitution provides for that case. Article 9, Section 6, quoting the relevant part, all other grants, gifts, and devises that have been or hereafter may be made to the state, not otherwise appropriated by the state, or by the terms of the grant, gift, or devise, shall be paid into the state treasury, and together with so much of the revenue of the state as may be set apart for that purpose, shall be faithfully appropriated and used exclusively for establishing and maintaining a uniform system of free public schools. Now, the defendant's argument in this case is that they are otherwise appropriated by the terms of the grant, gift, or devise. That's exactly the argument that Cooper versus Berger addressed. Cooper versus Berger said there's no separate category of custodial funds that are subject to executive control rather than legislative control. So
what do those words mean?
What that means is there's not a separate body of funds existing out there that are somehow outside of legislative appropriation authority. So if there was an agreement between the General Assembly, or I would say even the Attorney General, the General Assembly's authority would still be to appropriate funds to follow that agreement. Now that's Richmond County versus Cowell, I think is the high water mark of the General Assembly's authority. We argued that in our brief. In that case, there was a judgment against the state of North Carolina, and the court said, we don't have authority to appropriate funds from the state treasury, even though there's a judgment. The General Assembly should appropriate funds from the state treasury, but we can't require them to do that.
So by the terms of the gift or devise, that's just, those are suggestions to the General Assembly as to what to do?
I think if there were no, if the General Assembly had not passed 147-76.1, requiring all of those funds to go into the state treasury, I think that language might control in this case. But when the General Assembly said all of the funds have to go into the state treasury, it said we have control over all of those funds. And I would also point out that as it relates to the terms of the grant, gift, or devise, The Attorney General's argument is the terms of the grant, gift, or devise are the Attorney General gets to appropriate those funds. That's not an appropriation. That's saying this is the person we think can appropriate those funds. The General Assembly has honored the terms of the Smithfield Agreement by saying these funds are going to be used for environmental enhancement. There's nothing inconsistent with saying, okay, we as the General Assembly are going to say environmental enhancement at the public schools. That doesn't undermine the agreement. And the best evidence of that is my friend on the other side's memorandum of additional authority that Smithfield is still making payments. They know that there's been a judgment from the Superior Court that says these payments are going to public schools for environmental enhancement. They know that that judgment could get affirmed at this court. They're still making the payments. If they believe that the state of North Carolina was in breach of contract, one of the better things that they could do is say, we're not performing because you're not performing. We're going to take you to court and say, no, we wanted the Attorney General to have control over these funds. But they haven't done that. They've continued paying those funds because those funds are still going to the purpose that they were enacted for, which is environmental enhancement. So there's no issue there with whether or not the funds are actually being used for their purpose. And that gets to the point of the legislative appropriation, which if you read the State Budget Act 143-1-2 says that only a law expressly drawing funds from the state treasury is a legislative appropriation. Laws talking about the purpose of a fund or who may designate the funds or so on and so forth, that's not enough. It has to actually expressly draw funds from the state treasury. And that's the problem for my friend on the other side. They can't point to a law other than the recommended base budget, which says seized and forfeited assets, that expressly draws money from the state treasury. The Smithfield Agreement doesn't say it. 147-76.1 doesn't say it. None of the statutes that they've pointed to say these funds need to be drawn from the state treasury. It's only the recommended base budget that says seized and forfeited assets. And they cannot provide an interpretation of that language. That's why they argue that language is inaccurate and doesn't accurately reflect the use of the funds. That's just not good enough when you're talking about the state budget. The General Assembly's appropriation controls there.
In 147-76.1, the legislature did bind itself by the terms of that statute that it would be bound by the terms of an instrument evidencing a cash gift or donation. It says the terms of an instrument evidencing a cash gift or donation are binding obligations for the state. What terms does the state have to abide by and what terms does it not? So we're talking about appropriations. Is that a term? How do we reconcile those?
So
The legislature says if there is a gift or donation to the state, it has to go to the general treasury, but we, the legislature, will be bound by the terms of that agreement.
yeah,
So as not to put somebody in breach, right?
It's interesting that it says a cash gift or donation, because normally a cash gift or donation isn't an enforceable contract that you have consideration on each side for. I believe the funds at issue here are grants. That's still within Article 9, and that's in fact what the agreement between the Attorney General and Smithfield Foods calls them. It calls them environmental enhancement grants. So that's one argument that they're not governed by this cash gift or donation language. But even if they are governed by this cash gift or donation language, what are the terms of the instrument governing the evidencing the cash gift or donation? Well, the terms of the instrument are that the funds will be used for environmental enhancement purposes.
That's not the only term, though, right?
Sure. It also says, as designated by the Attorney General. I think the General Assembly can say, what we believe the terms that we are binding ourselves to follow are environmental enhancement. That's what we're going to do. We will pick the environmental enhancement for public schools, and the Attorney General's authority to designate those funds is no longer part of the cash gift or the terms of the instrument that are allegedly governing.
So 147-76.1, they get to bind themselves by the terms of the instrument, and then we'll add in there that we agree with? Are we adding something to that?
I'm not sure we are adding something to that.
That we want to be?
I think hypothetically the General Assembly could obviously undo this legislation or supersede this legislation in other
For
legislation.
future funds coming
Yes.
in, right? So we're still looking at 19 through 25, right?
That's correct.
Okay, and this was enacted when?
147-76.1 was enacted in September or October of 2019, but it relates back to funds from July 1st, 2019.
Okay. So
Um,
this is in place during the whole time that we're arguing about the funds that were.
That's correct. And that's why we're arguing about the funds that are at issue here, because this says those funds need to go into the straight treasury to be subject to legislative appropriation. And I think the General Assembly gets to interpret, sorry if I'm a broken record about the General Assembly's authority, but the General Assembly gets to interpret what the words of its statute mean when it says we're going to hold ourselves to treat these as a binding obligation of the state. And the General Assembly's decision in this case is the part that's binding is environmental enhancement. We're just going to use a different means to distribute it. I would liken that to saying if I have an agreement to pay someone $200, what matters is that I pay them $200. It doesn't matter whether I pay them cash, check, credit card, Venmo, as long as they get the money. And that's the purpose of.
But that wasn't stated in the agreement that you would pay them by cash, Venmo, or check, right? And so in your hypothetical, you're reading words in that you didn't do. And in this one, you're saying that we should add words. Guess I'm confused about that. It doesn't say that you'll pay it by Venmo, so it doesn't matter.
Sure.
Here it says the terms of the agreement, and the agreement says.
As designated by the Attorney
Correct.
General. I think as it relates to that point, the General Assembly, again, has the authority to say, we're going to appropriate these funds. We have voluntarily bound ourselves in this law, and if the court reads that as saying, you are not following the terms of this law, the General Assembly has the authority to say, no, we're not binding ourselves anymore. We retain legislative authority, we retain exclusive authority over the appropriations by the state of North Carolina. But all of that, again, presumes that these are a cash gift or donation. And I think they're a grant. It says cash gift or donation. The agreement says grants. I don't think the terms of this statute govern grants.
What's the difference between a cash gift or donation and a grant in your view?
I think the key difference is that a grant is something that's generally evidenced by a contract. So if the other party says you haven't followed the grant, they can take you to court. A cash gift or donation, you can't sue someone to say you didn't pay a gift that you said you were going to pay me. Voluntariness is a key element of a gift. If someone says, I'm going to give you $20, and then next week they say, oh, changed my mind, I'm not giving you $20.
Your colleague on the other side seemed to represent earlier that you all agreed that these were gifts.
Our complaint is very clear on this. It's paragraph 18. It's, I would say, record page 5, but apparently my record pages have been off today. It's paragraph 18 of the complaint. It says that they're funds received by the state of North Carolina. That's the argument, because 147-76.1 says all funds received by the state, including cash gifts or donations, shall be deposited in the state treasury. And then for Article 9 purposes, what's critical is that it's grants, gifts, or devise. So if you say it's a grant, it's still governed by Article 9. Thank you, Your Honors.
Got a little more than 8 minutes.
Okay. Just like to make a few brief points, mostly pointing out what you didn't hear from my friend on the other side. So first, with respect to the 21 through 25 funds, I didn't hear any response to the point we made about what the state budget actually says and that fund codes control here. My friend's argument essentially interprets the recommended budget that was approved by the General Assembly without change as if we're reading the abstract, as if there's no governing principles here. But the State Budget Act was incorporated by reference into both of the budgets that were enacted, that are issued here in Section 43.1 at the back of the budgets, and that's typically how budgets are enacted always. So the State Budget Act controls here, and so we have to interpret what the General Assembly did with respect to the State Budget Act. And they didn't respond to anything I said on that. The second point I'd make about the 19 through 21 funds is I think, as I was listening, I think in a nutshell their argument is that if funds are in the state treasury, then basically the requirement that the funds need to go to schools or rather funds only need to go to schools if they're not appropriated by the terms of a grant, gift, or devise just don't apply if it's in the if it's in the Treasury. But that's not what the provision says. The provision doesn't say that funds that are in the state treasury that are not appropriated by the General Assembly have to go to schools. It instead turns on what the terms of the gift are about whether or not the school payment requirement. So I would just encourage the court to read the plain text of that provision, and I think you'll see, oftentimes we get confused about things, and the crucial thing to do is to identify the governing rule, and the governing rule here is the plain text of that provision. I think if you look at it closely and read very closely, you'll see that because the gift clause just simply doesn't apply here. And my third and final point, I'd like to address standing. So as I take my friend's argument, he believes that there's no need to show a direct injury here because these are constitutional claims and because they challenge executive action. But if you read Farrington, they say that you have to show a direct injury here. That's what Farrington says, and we can't ignore what a unanimous decision.
The procedural posture in Farrington is different than this case, though. In Farrington, they were challenging the constitutionality of a legislative act. And that's the distinction that Mr. Gibson was attempting to make, that there's a difference between general taxpayer standing to challenge the constitutionality of a legislative act versus relator status like we have here.
Well, I think Farrington was a little more complicated than that. I think the plaintiffs in that case were challenging a local executive action, and then the court said, no, actually what you're really doing is bringing a challenge to one of the General Assembly statutes. And so it's a little more complicated than that. But then also, a unanimous court says, if you're challenging legislative or executive act, you have to show a direct injury. And I don't think other case law shows that there's a distinction in taxpayer standing with regard to legislative or executive action. I mean, if you look at Goldston, for example, which is another case we cite, and the parties both cite that there's no indication there that different rules apply in these contexts. And that would be an extremely difficult rule to administer as well, too, because the line between facial and as-applied challenges are very blurry. And that's what as-applied challenges really are, a challenge to an executive act.
Yeah, I think the distinction that they were trying to make is that there's a difference between taxpayer standing generally and taxpayer standing as a relator for some government entity.
But that's not what Farrington says. Farrington is a relator case. And Farrington says that there are certain things have to be done, even in a relator case, to show taxpayer standing. You have to allege you're a taxpayer, you have to allege you have a direct injury, and you have to have made a demand that was refused. So that's a relator case, and the Supreme Court in a relator case says you have to show a direct injury. So that would be wildly inconsistent with what Farrington says if this court were to go against that. And I think in a nutshell, my friend's argument about why they could show a direct injury is he says basically we pay taxes. And so therefore we have taxpayer standing, and that's a direct injury. But that's not what Farrington says. Farrington talks about establishing taxpayer status and direct injuries being separate requirements. So they have to show something more than just being a taxpayer, and that's baked into the reasoning of Farrington. So if there are no further questions, we respectfully request that this court reverse the decision below.
No, I got a question.
Oh, go ahead.
Sorry. I just want to go back to, we were proceeding all along that perhaps this was a gift. Can you address whether this is a grant, and if so, how that changes or impacts the analysis?
Well, let me since again, this is a surprise, this is not something that I understand has been briefed. I think as well, this is clearly by any reasonable means a definition of the term gift, a gift. Smithfield agreed to give these payments to the state. The Attorney General is making grants. There's no question the Attorney General is making grant, but Smithfield was under no obligation to come in and make these payments. That's what the whole first Stein 1 case and Stein 2 cases were all about, that Smithfield was not making these payments to settle any civil penalties or anything like that. They were of their own volition, without any obligation to do so, making these payments to try to rehabilitate their public image. Because what had happened was that in the 90s, hog lagoons repeatedly spilled over, damaging the state's environment, and Smithfield had taken enormous hits to their reputation. And so to try to make a gesture to improve their image and to try to help the state, they agreed to give these funds to the state. And that's a gift. That,
So it's your argument that Smithfield gave a gift and the AG gives out the grants from the gift?
correct, exactly. So Smithfield gave the gift here, the Attorney General gives the grants. And again, I find it surprising that we're talking about this here today because this has never been a focus of their, they've made this case about.
Any more questions?
Thank you.
Thank
We
you.
we would respectfully request that the decision below be reversed. Thank you very much.
Thank you. Thank you both. Excellent arguments. Appreciate it. Gabelat?
All rise. Court adjourned.
Tim, good to see you.
Yeah,
Good job.
Likewise, I wish we had like a classroom full of school children here to see this today. That's, I don't know, it felt like there were maybe like 300 kids back there or something, like in my memory.
Yeah.
I doubt it was that many.
I don't think I was there.